Hi, my name's Barb Graham, and I'm a staff attorney with Catholic Charities of the Archdiocese of Milwaukee. Today we want to talk about something called VAWA Cancellation of Removal, which is a way to defend yourself if you're in removal or what we think of as being deportation proceedings. So there is a law that protects domestic violence victims called the Violence Against Women Act, and usually we just call it VAWA. Although it's called the Violence Against Women Act, it protects men. In fact, almost 30% of our domestic violence victims are men. For example, one of our male clients was married to a woman who is a United States citizen, and she simply paid two men $2,000 each to beat him so badly that he was in the hospital for a month. Another United States citizen woman took a steel shovel and hit her husband in the face as he opened the garage door. She broke all the bones around his eyes, broke his teeth, and he too was in the hospital. So just because you're a man doesn't mean you can't be a domestic violence victim. So there are two kinds of VAWA. There's something called the self-petition, but then there's another kind of VAWA that you can ask from an immigration judge. In this video, we're going to talk about the one that you get from an immigration judge in something called deportation proceedings. Now you remember, you can't get VAWA just by starting this process yourself, and you can't get it by applying to United States Citizenship and Immigration Services. Instead, this is something you use as a defense to being deported. In fact, rather than being deported, you would walk out with lawful permanent residency. So, an immigration judge can give you the Violence Against Women Act and lawful permanent residency if the person has been subject to extreme cruelty or battery by a United States citizen spouse or parent, by a lawful permanent resident spouse or parent, or by a United States citizen child who is at least 21 years or older. VAWA cancellation can be granted to anyone who is married to an abusive lawful permanent resident or an abusive U.S. citizen, is the biological, adopted, or stepchild of an abusive lawful permanent resident or U.S. citizen. Now, to qualify as an adopted child, the adoption must have been completed before the child turns 16. The immigration process doesn't have to be complete, but the adoption does. To qualify as a stepchild, the parent and the step-parent must have been married before the child turned 18. It's also available if you have a child in common with a United States citizen, lawful permanent resident, or United States citizen. In this situation, you don't actually have to be married to the abuser, but you do have to have a child in common, and the child has to be a victim of extreme cruelty or battery. You can also be the ex-spouse in an abusive lawful permanent resident or United States citizen. Now, in contrast to what we think of as being the self-petition, that would require that you apply for a VAWA within 2 years of a divorce. But for VAWA cancellation, it doesn't matter how long ago you've been divorced. You can have been divorced for 20 years or 30 years. You can still ask for VAWA from an immigration judge. Finally, you can also be just the intended spouse of a lawful permanent resident or United States citizen. This, generally speaking, protects people who think that they're married, but the abusive spouse is really a bigamist, that they'd been previously married and that they had never divorced. Now, physical and emotional violence is something that a lot of people don't understand. They don't understand that they're domestic violence victims. Domestic violence isn't just physical, it's also emotional. For example, someone who constantly berates you, undermines your self-esteem, curses at you, and is emotionally abusive. The United States citizen characterizes any similar behavior as abuse, regardless of the fact that these actions may be culturally acceptable in your home country, or even expected in some countries. But as a result of this, there are an awful lot of domestic violence victims who have no idea they're domestic violence victims. Alternatively, many immigrants who are victims of domestic violence do not report the abuse because they fear the police at least as much as they fear their abuser. However, the United States takes domestic violence very seriously, and your right to report your abuser is protected by law. You also have to show extreme and unusual hardship for the Violence Against Women Act, or VAWA. But this Violence Against Women Act extreme hardship requirement is very different from some of the other hardship requirements. You have to show extreme hardship, but this time you count as one of the people to whom you can show hardship. You can either show hardship to yourself, to United States citizenship or lawful permanent resident parent, to United States citizen or lawful permanent resident spouse, or United States citizen or lawful permanent resident child. But when you think about hardship to yourself, think about things like, am I getting mental health care here? Am I getting medical care here? Do I have access to police protection and restraining orders here that I really wouldn't have in my home country? Finally, you have to show that you're a person of good moral character. Now, good moral character is never really defined. There are certain things that will show that you can't have good moral character. If you've had any contact with law enforcement, you want to talk to a competent immigration attorney to sort through the good moral character issues. You also have to have been physically present in the United States for 3 years. Now, unlike most cancellation cases, if you've seen our other videos, there are certain things that stop you gaining or accruing your 3 years. The Violence Against Women Act at the court, it's really different. You keep accruing your 3 years or getting the 3 years you need to stay up until the day you have your hearing. It doesn't stop when you're told to go to court. If you leave the United States for more than 90 days or 180 days altogether, you can break that 3-year requirement. But practically speaking, the immigration court is so booked, there's a really good chance you'll have 3 years in the United States before you even get to see an immigration judge. But this is one of the things that you cannot do on your own. You really do need to find a good and competent immigration attorney to help you see if there's any kind of a waiver you could qualify for, especially if you've had any kind of contact with law enforcement. We have a link of immigration attorneys that are in our local area. We also have a link to the American Immigration Lawyers Association where you can find an attorney who practices in the immigration area.